Hello, once again. Welcome to the Digital Rights Africa podcast. Today we're on the fringes of the Data Protection Africa Summit. And I have two guests that are from the summit, and I want them to share with us ideas and what they are getting from the summit, what their work in the data protection space have been like. Because we're in South Africa and I've not been very good at pronouncing some of these names, I will let my guests introduce themselves. So let me just come to you first. My lady, introduce yourself, and I'm hoping that I'll pick up the name as we go along, and then we'll move to the gentleman. So ladies first.
Thank you, Teki. And hello to your viewers. My name is Babalwa Kilani. I am a lawyer by profession based in Johannesburg, specializing in data protection. At the moment, I am a privacy officer for a payments facilitator company, and I'm looking after the Africa region.
Okay, that's very interesting. And
good afternoon or evening, good morning, whenever you view this, to the viewers. My name is David Dickens. I'm the CEO at the DMA SA, that's the Direct Marketing Association of Southern Africa. What are my credentials? To work at an NPO, non-profit company, one has to be everything and wear so many hats. So I started out as an educator. I studied IT. I got a passion for databases. And then when I got into the industry, I kind of was wanting to know more, so I did a master's in the effectiveness of direct marketing in Southern Africa. So for those sins, I was pulled into the DMA to head it up, and it's been a great journey, a lot of learning.
That's very interesting. I think that it's really, I'm really excited to have you both here. You work across different spectrums. Definitely direct marketing is one of the areas that is always very controversial when it comes to data protection. So I would love to hear more about that. And Babaluna, so you have been working across Africa. I know that a lot of the time when we engage with people on the side of the summit, they're always concerned about, Africa, 55 countries. Everybody has their own legislation. How has this been for you? Is it fairly easy to navigate this landscape?
I would say it is a challenge. Right now, I'm dealing with, I would say, South Africa, Kenya, and Nigeria as one of the regions. And when I contrast how they deal with data protection, the principles are more or less the same, but how the regulators implement those for their regions, it's a bit different. So you'll find that, for example, in Kenya right now, controllers and processors are supposed to be registered with the Office of the Data Protection Commissioner. And how you do that is there's like an assessment where you fill in your processing activities and you send it to the regulator for approval. Whereas in Nigeria, it's more of a hands-on approach whereby there's annual audits for certain controllers, and that entails you working with an organization called a Data Protection Compliance Organization. So you'll work with a professional services firm to make sure that you're ready for the audit, and they sort of guide you and make sure that you're complying with Nigerian law. Then you come to South Africa, and it's a bit different here as well. So the principles still remain the same, but there's little nuances. For example, in South Africa, a juristic person is also covered in our law, which is called the Protection of Personal Information Act. So when you are doing your compliance program and making sure that you are complying in each region, you have to take into account that, yes, there is a standard, however, there's little nuances that you have to make sure that you're complying with in each region.
I will come back to you. No, I think we should go on that, because otherwise we'll lose the train of thought, and then we'll come back to David, because he also works across borders. What does that really entail, apart from getting the work done? Is it cost efficient? Is it, what does that mean for your organization? And what are the real challenges that you face having those differences? And if you had a magic wand, what would you request for? Yeah.
Let me first say, if I had a magic wand, I would wish that they all harmonized and you kind of report to one body instead of having to report to each regulator, or at least have one uniform standard. How that affects us in terms of the rands and cents, right, business-wise, is that when we're entering into a new country, now we then have to seek legal assistance from that in that region. And so it's either you have to hire new people or seek legal advice, which is costly. If we had like one sort of standard, then everybody would be able to sort of make sure that they comply with that standard, which is less costly.
David, let me come to you. So you work in direct marketing, obviously not just within South Africa, but across. What are the members of your association saying?
So just to take a step back, direct marketing, we started in 2005 before, as you were saying, the Protection of Personal Information Act was promulgated. Business came, especially responsible business, said, let's have a set of rules because it's kind of chaos and it's a wild west. There was spam. If you remember back then,
yes.
People did this shotgun approach, pray and spray. Wherever that email lands, someone will buy my product.
Yeah.
It was incumbent on business and said, no man, we want to raise the standard and professionalize ourselves. And very much like what Babalwa said, it would have been great if we just had a magic wand and we could get everybody to comply. But they're definitely challenged because you've got local companies, you've got multinationals, and they then have their stringent rules from the GDPR, and then we've got POPIA, and so they got the right to the two and harmonize those two in their companies. Our experience is that business wants to comply. The challenge is that POPIA's new legislative piece and the office of our regulator has just been put into being, and there's a lot more education I think we need out here in Southern Africa. We're making good progress thus far.
Okay, I think this question goes to a lot of you, especially when you said that, the office have just been set up. There needs to be a lot more awareness and education. How have the regulators in the different regions that you operate with, how have you worked with these regulators, and has it been beneficial, or you think that there's a lot more that could be done in this space?
I think we've worked well. There is progress that's been made. However, there's still more to be done. So you'll find that in other African countries, there's a lot of, there's frameworks, there's regulations, and very legalese documents in terms of how to comply. But that's sometimes not easy to understand, even for a legal person, especially if you're dealing with multiple jurisdictions and you want to comply, which is what business wants to do. So I think the solution there is really simplifying the language and having more examples. I know within the EU, they have the EDPB guidelines, where in that document you'll find they'll give you an example of different scenarios, and one of them may be applicable in your circumstance. So I wish our regulators would, yes, draft the legal documents, the regulations, frameworks, and so forth, but also have easier to use documents that even the man on the street could understand.
That's a good call. David, what about you?
Similarly in the direct marketing sector, we have a cross-section of small, medium, and large corporates. The corporates on the top, they've got a whole floor of lawyers, so it's easy. Well, not easy, but they've got their compliance that they can get through. It's but if you look at our economy, we are run on really medium to small businesses that run us, and the challenge in our economy at current is, you get into your business, you roll up your sleeves, and you do what you do. You're not a lawyer, so now you got to read this complex document, like Babalwa was saying. It's a challenge. So what we would like to see, and what we do at the DMA, we push out these 12 guideline steps in really practical terms. We also we break down the 8 principles of POPIA that guide us in terms of POPIA in those guidance principles. But to come back to POPIA, what we've seen the regulator doing and how we've been working with him, it's been a challenge in the last, I'd say, 7 years, because there was POPIA is coming, POPIA is coming, POPIA is coming. and then everybody was like, lawyers were making lots of money scaring everyone. You need
I'm a lawyer. In fact, there are 2 lawyers here, so be careful what you say.
We had to, so at the DMA, we had to say, guys, let's just bring the tension down, because
I hope you engage lawyers though,
no,
to
we
help
do.
you. Yeah, thank
They
you.
are I mean, they are staple at the DMA.
So we're not bad after all.
No, not all.
Yeah.
But yeah, I think there, when there's uncertainty, it costs money. People start paying for things they shouldn't, and the guidelines, if they were broken down very practically, the small guy that owns a pizza shop can understand, hey, I can collect his name and his cell number, and then give them every weekend an SMS saying there's a special on 2 pizzas and a Coke. That is as practical as direct gets, to the more complex.
Okay.
So they need to know, how far do I go with
yeah.
POPIA?
Okay.
Do I need to pay R1 million to a lawyer to get my POPIA code done?
Do your association members work mainly in South Africa or across Africa?
We're a Southern African, purely South African association, but we sit on the board of the GDMA, where all the 42 DMAs, we got DMAs.
Okay, so I don't know whether you can answer this, but it's especially on the light of some of the issues that we've been discussing on this conference around cross-border data flows, the digital economy, and opening up of Africa. I just wanted to know whether you have, paid attention to what the direct marketing environment looks like when you're looking at it from the lens of Africa and the data protection laws.
So, although we are direct marketing South Africa, our companies are multinational as well. So our legal team will guide them that POPIA, yes, while you're in
maybe
South
they
Africa.
opt out, opt in.
Opt out.
Yeah.
And some legislations are just opt out.
Opt-ins.
They're not purely opt in. So we advise them on the duality of the different legislative pieces in their countries, but and then always take the higher ground. Whichever piece of legislation asks you to do more, rather do that than less in terms of compliance, because we're always speaking to our stakeholders. We raise the bar, especially as an NPO. We're not taking a shortcut, and neither are we watering down the legislation. That would be detrimental. We actually want to raise the bar of professionalism. Do this plus, and be values based. And if you find it, people look for, human beings.
Yeah.
We want to look for that gray area, and we say no, be values based. Say if you can do better, do it better.
What role do you think what place do you think industry codes will have in this place?
I think it's vitally important that and from my understanding, what you're asking is in a country where you have the regulator as government, and then we are industries on the ground in the sectors. I must say our government's really working fast, our regulator,
Okay.
Advocate Pansy Tlakula heads up the regulatory body, the Info Regulators Office. She's called me many times to speak about direct marketers.
Okay.
Because we really do tend to push the boundaries. They're marketers.
Okay.
And then I find myself having these conversations. So it's important for somebody like, they say, we've got guidelines out now saying that the biggest, most representative bodies can bring a code, an industry code, submit it to the regulator. The regulator will then look at the code against the guidelines. And if it's acceptable, will go and be gazetted at Parliament and then go through a whole rigorous program where everybody in South Africa will look at it and say they accept it, they don't accept it. And then you get the industry code stamp of approval so you can work closer with government. And I think that's going to really change the game for us.
What do you think about your industry that you work within? Do you think an industry code will work? And especially when you work across borders, how do you think this can solve the problem of, you know, the cross-jurisdictional nature of the laws? And
I think it's a bit more complex, especially when you're dealing with payments from different countries. Data subjects are different nationalities. And so for now, I think it would be valuable to have a code approved by the regulator for the payments industry, especially because the people within the industry know very well what's happening. And the collaboration with the regulator in approving the code and giving guidance will provide a lot of clarity in terms of the processing activities that we do, as well as the rights of the data subjects and our responsibilities as controllers or processors or whatever other capacity we're acting in. So I think it's very important, and hopefully we will get to that stage. I know other bodies have already had codes approved, the Banking Association of South Africa, the Credit Bureau as well.
Okay.
So we are moving towards that. How that works between countries, especially African countries, I think there needs to be a broader conversation of how do the regulators also work together in enforcing these codes, because we also need a standard first.
Some kind of recognition of each other's laws and standards that they've set up within. Now, I know that one of the biggest issues that we see as an NGO in this space, which is one of the reasons we have the Data Protection Africa Summit, is capacity in the space of data protection in Africa. And that's extremely important also because, you know, every sector, I always say that every sector, data protection is nuanced in a very different way in every sector. And so typically what you require, even for a regulator to be able to properly address the needs of the data controllers, you know, and give proper guidance, is to really understand their work and how they do it. How have you, because you come from two different backgrounds, how have you really dealt with this issue of capacity, and what do you think we should be looking at in the future? I'll start with you, David.
I think capacity most definitely is a challenge. We have to go back to economics as well. NPOs and NGOs, we're in a really depressed cycle globally. And we rely on businesses to assist us to help them back, you know, in a sense. And many of us rely on our member subs to do a really big job. If you come to my office, you'll think there's 100 of us, but there are very few of us. We've just gone very tech savvy. So what we've had to do with our limited capacity, because we're in the tech space, we actually use technology to, you know, to have a greater impact. But there's two parts. The associations are limited, but also government departments are limited. So we try to work from a point of understanding there are tensions where we say, where industry business goes, the government should be doing more of this. They should be doing more of that. And then we go and we have a meeting with them, and they'll say, the budget is the budget. And then that's where we come in as NGOs and NPOs. We pick that up and we go the extra mile with them, partnering government in a sense. And now it's very heartwarming that we are now being able to do it from a legitimate point where your code now gets ratified by them. And you say, okay, fine. Now you're actually taking notice of me. I will be around the table when you start deciding how POPIA or the Act evolves, as opposed to there were judges, there were parliament, and we were here, and then we were told
What to
we
do.
weren't included in the discussion. So the inclusion would be great. And when we included and we're given a stamp of approval, it really raises us and we get more resources. So it's a good knock-on effect for us. When we get our stamp of approval, I see that as a win. Because, you know, like that magic wand, if I had more resources, I'll do more education, more training, more SME development. And it'll
But do you think that as an association, your members have the capacity that is required to implement data protection?
Absolutely.
They do?
Absolutely. Well, if I take a cross-section of my membership, there are the struggling entities. And that's where we come in. I mean, at the DMA, what we've done is we've actually taken some of the money from our membership and we create something called a DNC, the Do Not Contact Center. It's an application where we've gone we've put up money and we said, guys, here's a suppression list of South Africans. Because some of our smaller guys don't have the tech capability. So every time before they launch an ad, they'll clean their marketing list through the DNC and they respect the rights of the consumer to opt out. So that's like we're helping in a practical manner.
What about you? Resources and capacity for capacity building, do you have it?
It's a big challenge. It really is a big challenge because data protection is relatively new. It's relatively new in South Africa, Africa as well. So there aren't a lot of skilled people in the industry who can actually assist business with complying with the different data protection laws that are applicable to them. I think when you are in an organization as someone who has expertise in that area, it is your responsibility, especially if you can see that there's not a lot of people who can do the job, to upskill the different operators or resources within the business, because our role is to advise and to guide. But the actual people who are dealing with the information, you'll find it's different departments. So it will be your marketing, it will be your tech guys, it will be the sales people. And so we need to make them more aware of personal information and how to protect it, as well as to upskill them so that in their area, they can be the privacy champions, because you won't have privacy experts in everywhere. Business just can't afford that. So how I think we can move forward is just more education, more training, and just upskilling the people you have.
Who pays for the training? Just don't answer that. I think we're coming to the end. So I just want to, take your concluding remarks. And that's on the big question, how do you think, we should be going in this area? We've spoken about a lot of things, but just as, some last words for our audience, hopefully some of them will be regulators that can take up some of the wisdom that you will be giving out here. So I'll start with you, David, and then end with her.
I think attending the seminars, much like this, has been extremely helpful. It also gets you get to understand, where am I right now, South Africa? Where's the rest of Africa? And I liked what Uganda had going. The boo-boo, buy Uganda, brand Uganda. I wish we could steal that for South Africa. And then really, I'm talking about the resource. If we could use South Africans to do our own security, to write our own, tight secure platforms. But like we were saying, in all practicality, a lot's come from the West, but I think we have a wealth of resource in South Africa, South Africa, if you care to look. So let's start, developing our own internal skills platforms.
Okay.
Let's start looking at ourselves. And then I sit on the GDMA, the Global Data Marketing Alliance, and I can tell you we are way ahead of many countries in terms of our compliance. And we must start believing in ourselves more. A lot of our brains are getting exported in IT. Because we're not developing our own infrastructure and tech savvy systems in South Africa. So we should really start looking towards ourselves and believing more that we've got it and we're doing it. There's billions of rands of trade that runs in Africa. So let's hold it here. We've got the resources. We should not be this poor.
Okay.
That's the enigma.
Yeah, the enigma. All right, so over to you. Final words?
For me, collaboration has been a big theme of the conference, and I wholeheartedly support it. In order to galvanize the digital economy in South Africa, in Africa, as a region, we really need to start collaborating as professionals, as well as the authorities, the authoritative bodies as well, to make sure that we're all striving for one standard, which will make it much easier for things like cross-border flows and trade within one another, and making sure that, yes, there is the international community and the international standards, but we should also strive for Africa's nuances, African solutions for African problems, but also making sure that we are still marketable as a region internationally, because we want those foreign direct investments as well, right? So for me, collaboration is a big theme, and hopefully we are moving towards that.
Thank you so much, ladies and gentlemen, for joining me. You heard it from them. There's still some work that needs to be done, but obviously a lot has been going on. We have what is required as a continent to develop a very vibrant data protection ecosystem. We probably need to put in a lot more resources. And I think for me, one of my takeaways is that collaboration. In order for Africa to move forward, we really have to collaborate, whether at the regulatory level, whether at industry level, whether at a civil society level. We need to start talking more to each other. Thank you once again for joining us. All too soon, we have come to yet the end of another episode of the Digital Rights Africa podcast, where we talk about everything privacy and data protection, child online protection, intellectual property rights, and cybersecurity issues in Africa. Join me soon on another episode. Bye.